Right, excellent. So anyone who's coming on as an attendee will now be able to join us. Welcome everybody, thank you for coming. My name is Simon Harding, I'm one of the barristers of 36 Group. This is Richard O'Dare, and here we have Tenny from OTS Solicitors, and we have Hans as well. So welcome one and all. Today we're going to be talking about, mostly from the claimant point of view, just a little bit of information about COVID-19 and how it affects employees. Now, just while we're waiting for just a few other people to join, welcome. We've got Catherine, we've got Marianne, we've got someone called User. So welcome User and Haroon. We've had a few questions by email. So excellent, some more people coming on. I just want to check that I am recording this properly. I think I am. So that's good. So that will be made available later on. So what I'd like to do to start with is, I just thought I'd have a little circle around where we are with COVID-19. And of course, anyone that wants to participate, please jump in. But it seems to me that we're still looking at 2 weeks worth of lockdown, if not more. And the government, of course, have not announced yet anything about when the lockdown is going to be released. And that, I think, is strategic. Today, I don't know if anyone's seen, there was an interview in the paper with Ken Clarke and Norman Lamont, both two former Conservative chancellors, and they said that they felt that the government's deliberately not announcing when there's going to be an end, because if they do, the problem will be that then everyone will expect that to be set in stone, and the problem is that it's very fluid, and we just don't know. So that's what the two esteemed former chancellors have said. Whether that's right or not, I don't know, but we will see. What is clear, though, is that regardless of whether the lockdown occurs in 1 week, 2 weeks, or 4 weeks, it's going to be gradual. And it's going to have a long-term effect on business, because businesses won't be able to just start immediately. There'll be a run-in. Obviously, some businesses will be allowed to open sooner than others. The release of restrictions will be gradual, by all accounts. So where I live in Shepherd's Bush, they're already beginning to open some shops on a local level. So dry cleaners have opened, cafes have opened for takeaway, and I don't know whether it's just the people voting with their feet, but there seems to be a gradual systemic opening up. But the problem, of course, is the long-term impact this is going to have on businesses and their ability to create cash flow. That is going to be the big issue, because if it takes 3 or 4 weeks for a business to start to get people back in, then of course that means cash isn't going to flow through the business for a long time. So the important thing, I think, for all those of us who are employees, and this, of course, is who this seminar is. Welcome to Dale and Faith, who've just joined us. The difficulty with those who are employees is, and I think I've seen a bit more of a hope on this in social media, is people seem to think that as soon as the lockdown is released, everyone's going to get back to work, all the money will start flowing through the economy, and life will carry on as it was before. And I have to say that I don't believe that is at all realistic or indeed likely. People have to spend money, and the money has to circulate its way through the economy before we have any real chance of economic life returning to what it was. And estimates vary, but 20 to 30% drop in GDP is estimates of the impact on the British economy alone. I just wanted to add a word of warning here as well about not being too distracted by what's happening in the stock market, because the stock market has gone up and down very, very dramatically in the last few weeks. Not just the FTSE, but the S&P 500 in the States and the European trading centres. And I wouldn't be too optimistic that means that the economy is in a great shape. It just means that people are short trading the market, is how I view it. Because there was, for instance, last week, the S&P 500 went up 12% in one day. And there was absolutely nothing behind that. There was no underlying reason for it other than people playing the stock market. So I've seen a lot of optimism that people have on the stock market, and they think that the economy will return to normal. I'm not convinced that there's that correlation yet. We didn't see that correlation in 2009, 2010. And so the stock market is a little bit of a false friend, I think, for judging the impact of COVID-19 on businesses. And the reason that we have to start looking at businesses first is because ultimately it's businesses who are the employers, and it's the employers who give the jobs, of course. And that means for any of us, or any of you who've been furloughed or face furlough or have uncertain futures, I'm afraid the situation is likely to be very volatile and very uncertain for a considerable amount of time. Whether that's right or wrong is a discussion to be had. So those really were just some preliminary remarks just to say to everyone, look, we can't be too certain of what the future is at the moment, and there's no quick fix. Before I ask Richard to give us a little presentation he's prepared on furloughing, I was just wondering whether any of our panellists here at the moment, Tenny, Hans, or Richard, had anything to say about my preliminary observations before we start. By the way, there's a Q&A, a question and answers box. I think you've got access to, those of you watching, so you can go into that. I will be opening that up from time to time. I also have the chat screen open, and I'll keep an eye on that as well. So if anyone has any questions or thoughts, please feel free to put them into that chat box as well.
I think my comment would simply be this, that while I don't disagree with anything you've said, the government has gone to extraordinary lengths to protect employees' basic living standards against the possibility of redundancy due to the COVID crisis. When we talk in a little while about the scope of the scheme, whilst there are gaps and it's possible to fall through those gaps, it is extraordinary the length to which the state has gone in support of employment. I think it's almost unparalleled.
Yeah, absolutely. This is the first time in history where there's been a bailout that's been aimed at the people rather than at the banks and big institutions, and that's worldwide. I think the shame of it is that it wasn't a lot more uniform and wasn't rolled out a lot more quickly. I think in the States it should have been rolled out 3 weeks before, but was mired in political controversy. At least in England and Wales, it was rolled out fairly swiftly. Perhaps could have been quicker, but this is the first time that we've ever had anything like a furlough scheme where the government is paying for people to be not working, or certainly not working with their employer. And so that is definitely to be welcomed.
I mean, it raises the question, which we'll look at a little bit more detail later on, why employers would choose to make employees redundant rather than furloughing them, because the government pays the basic costs, and for the staff, it's the difference between getting a reasonable level of remuneration and being on universal credit, effectively.
Yes, I mean, I think a lot of people, I mean, I certainly was advising companies very quickly on lockdown that was just making people redundant or laying them off straight away because of a knee-jerk reaction. Also, I suspect a lot of companies went straight for redundancy, as some companies saw it as a good opportunity to deal with staffing issues. It gave them a perfect excuse, as it were. So I suspect there might be some cynical reasons behind it as well.
Yep. Simon, on that, we've had quite a significant number who it's the furlough situation, or this situation, is the reason why they're putting through a redundancy situation, but the procedure and the consultation may not necessarily be followed correctly. So that's a point that's been a concern of a lot of clients of ours.
Yeah. Okay. Well, let's circle back to that at the end of Richard's presentation, because he's going to talk a bit about furloughing, but then let's come on to afterwards and have a around the table, as it were, discussion about proper exercising of redundancies and how they should be done. So, Richard, do you want to share your screen and launch into your presentation?
Yeah, absolutely. Hold on a second. Has that shared my PowerPoint?
Yes, well, I can certainly see it.
Good. Well,
I can see that as well.
Yeah,
Okay.
I can see, yeah.
Great. Well, I think
All right.
be
So the government announced the COVID 2019 job retention scheme in, I think, early March, and it has moved very swiftly to make the scope of the scheme clear and as transparent as possible. The striking thing about the scheme, amongst other things, is its extraordinarily broad coverage. You don't have to be an employee to be furloughed. You can be a worker, you can be an agency worker, you can be someone who is engaged through their own personal services company. That's the basis on which consultants are often provided to the public sector. You can claim furlough funds as a foreign national who would not otherwise be able to receive benefits in this country. One of the major qualifications to that, however, is that you must have been engaged and remunerated through the PAYE scheme. That is partly a matter of administration, but it has a substantive effect in that if individuals chose or were forced to be what might be called contractors, they will not be able to claim at all, though they may be able to claim as self-employed business owners through the parallel scheme which the government is running for small business. I should say very small, because the limits on the claim of such people are very low. If you're earning more than 50,000 in a year profits, you cannot claim under the small business scheme. Going on from there, what is payable? It's 80% of gross salary, or 2,500 per month, whichever is the lower. And that leads to certain individuals falling through the gap in the sense that if 80% of your salary takes you below the national minimum wage, that is what you are paid, not the national minimum wage. It's also a quirk of the scheme that if you are retained by your employer to do a much reduced contractual week, you can't claim anything at all. So if your employer pays you, let's say, a fifth of your salary, depending on the level of that salary, then you can't claim under the JRS. As I've said, the scheme is and was intended to be very broad. It was intended to provide a cushion for employees who are unable to work because their employer has no work for them due to the COVID crisis. And that raises the question, which is an important one, of why on earth an employer might choose to make redundant rather than to furlough. If you cast your minds to, I think it was yesterday's papers or the day before, there was a story about British Airways deciding to make up to 20,000 people redundant. And that really does raise the question, why would they do that? Given that redundancy as an option often involves payments by the employer, particularly depending on length of service and any applicable contractual redundancy scheme. Why would they go down that route rather than furloughing, where the costs are essentially borne by the state? Well, some of the answer to that scheme is, as Simon has said, panic. and knee-jerk reaction. It might also be deciding to get rid of people you wanted to get rid of anyway, and the crisis prevents the perfect redundancy excuse. But there have been other more subtle reasons advanced, and I have corresponded with certain employers on behalf of various clients about this issue as to why they refuse to furlough. One is that there's been, and there are repeated suggestions of hidden costs to the employer. So it's said, for example, well, what if the employee goes off sick while they are on furlough? Am I then obliged to pay statutory sick pay, which under the regime in place before the lockdown was a cost which the employer could not, as they used to be able to do, claim back through the national insurance scheme? The government has demonstrated in no uncertain terms its determination to make this scheme work, however, by providing a scheme currently advertised on the HMRC website, under which sick pay can in fact be claimed back by the employer. So that objection, as it were, has disappeared. Whether all employers are aware of that or not is, of course, another matter. The other thing that's said to have troubled employers is holiday pay. Will it be the case, as European law seems to provide, that holiday will accrue while the employee is away from the workplace? Again, I personally don't see that as a huge obstacle. And that is so because of the way the scheme works. The scheme is a voluntary scheme on the part of all concerned and requires a variation of the contract of employment. But that variation can be used by a well-informed employer to ensure that almost any hidden cost disappears. So, for example, the employer on a furlough scheme could take advantage, I think, of Regulation 15 of the working time regulations and provide that any holiday accrued in the previous week would be taken on the first day of the following week, so that the employer would get to the end of the furlough period without any holiday pay owing. In addition to that, of course, if the contract defines holiday pay in such a way that it's no more than a proportionate part of 80% of the previous contractual gross, then holiday pay being pay, that sum ought to be completely reclaimable through the furlough scheme. The other point to note is that some employers have introduced into the varied contract a payback clause, by which I mean a clause stating that if any sums are paid during the furlough period and not reimbursed by the government, they will be repayable by the employee. Now, while that's not an attractive prospect for employees in some ways, the risks, I would think, of any such clause being invoked are extremely small, and it would be a small price to pay and something an employee could offer to an employer who might appear reluctant to furlough. So on the whole, it seems to me that with some decent legal advice and bearing in mind the government's determination to make this scheme work for employees, ought not to be many reasons, for many good reasons, for an employer to refuse to furlough.
Can I add two?
Go on, Simon.
The first is, and I saw this a lot at the beginning, that because of course the employer has to pay the employee.
Yes, cash flow.
It's cash flow. So
Yeah.
if you've got a large workforce, and just thinking about British Airways, if you've got 20,000 employees and you've got to pay them that money on furlough, because of the nature of the schemes only just come online, the portal only became available, I think, last week, and the payments haven't started yet. For some businesses, there is a colossal cash flow issue. And I know a lot just took a view right at the outset that if the cash flow issue was going to last more than 2 or 3 weeks, it was just easier to make redundant because the redundancy payments were so low because most of the staff hadn't been with them for 2 years.
Yeah.
That was the first issue. The second issue is if you're a company the size of British Airways with 20,000 employees, actually what you want the government to do is to bail you out. And the way that you can force the government to bail you out is to say, I'm going to make 20,000 redundancies that will make British Airways go bust, because we then have to report up a massive redundancy payment. We've got no cash flow. We're trading insolvent. So they then make a big play of calling in the administrators, and the government have to bail them out. So I do think there is a tactical use of redundancies for very large companies to try and force much greater assistance from the government. Although, of course, in the last 2 weeks, the government have announced some very significant help to bigger companies, including allowing companies to issue what's called paper, which is a debt, and then the government buying that debt from the companies at a very low interest rate.
Right.
So there have been some movements on companies issuing paper, which the government will buy. But I suspect with BA, it's just, and Virgin, it's simply, if you want to have 20,000 people go on the redundancy, to go on the pay lines, just don't bail us out. It's just a power play, I think.
Yeah, I think that's right. I can see that. But of course, the inverse of that is that, or the obverse maybe, is that in the case of much smaller companies whose employees are not particularly highly paid, the cash flow argument may well lose a lot of its force.
Yeah, oh, absolutely. I mean, that really only works for companies with the clout of British Airways or Tesco or, you know, major employers. But for small companies, I think it was a short-term cash flow in April. I mean, the scheme is now in operation. But if you were looking at 23rd of March when we went into lockdown, that could have been 3 or 4 weeks paying 20 members of staff salaries while they didn't work. It could have been a very significant cash flow problem. But
I think that's right. But I was looking at the HMRC website today, and they're saying they're processing within 6 days, which seems to me to be a pretty quick turnaround, really, for a government body. And insofar as employees were dismissed because of issues that have now been addressed, it is important to notice that employers can choose to re-engage dismissed employees in order to provide them with access to the furlough scheme. So what happens, for example, and this is a question I'll address in the next slide, but if an employee goes to an employer and says, well, look, I understand there was a cash flow problem to start with, but look, it's taking 6 days now. I want you to re-engage me. What would be the legal position there? And I will answer that in my next slide, which says this: are employees obliged to furlough? Or I could have said slightly, in slightly more detailed terms, are employees obliged to furlough or re-engage and then furlough? The answer is different with respect to different categories of employee. It seems to me that if an employee has been employed for more than 2 years, such as to qualify for unfair dismissal, was dismissed in the initial, let's call it panic, fair word, after the lockdown occurred, and then goes back to the employer and says, well, look, you know, there's a scheme that will enable you to claim my wages back within 6 days. Will you re-engage me? And I think that there is a tolerable argument, a good argument, which hasn't yet been tested, that if they refuse to do so, that will make the initial dismissal unfair. And that is because when considering whether a dismissal is unfair, tribunals are required to consider the circumstances not only before the dismissal and at the time of the dismissal, but after the dismissal. That's why an employer can be found to have unfairly dismissed if they botch up the appeal. It's because, though the dismissal occurred prior to that, the failure to allow a proper appeal is one of those circumstances, albeit occurring after termination, which has to be taken into account. And I think that in these circumstances, tribunals might be very, very willing if the employer simply puts up its hands and refuses to engage, thereby disallowing for the employee access to the scheme. I think tribunals may be very well be open to finding that amounts to an unfair dismissal. There are another number of other issues, possible legal claims that arise from the furlough scheme, and they particularly occur in relation to female employees. What is the position if an female employee says, I want to be furloughed because I've got to look after my children who are off school, and the employer says not, and the employer either makes them redundant or simply requires them to attend work? I think that in those situations, there's a very serious argument about indirect discrimination against female employees who, regrettably, still, for the most part in our society, carry the lion's share of the childcare responsibilities. So I think there's a big claim waiting to be tested there. And similarly, older employees in the current climate may well have to be away from the workplace in order to care for elderly relatives. In those situations, they may want to be furloughed. And if the employer refuses and says, either come back to work or we let you go, again, I think there may well be an indirect discrimination claim on the grounds both of age and gender. So it seems to me that the issue for employers of to furlough or not to furlough, or to re-engage and furlough, or not to do so, is not as straightforward as it might seem. It's often said that employers have a choice to furlough under the scheme, but no obligation to do so. But I think I probably, hopefully, have convinced some listeners with my view that it's not as simple as that. Employees who think that their dismissal or refusal to furlough has generated a claim do, of course, need to be aware that the employment tribunal system has, if not quite ground to a halt, has come very close to it, certainly in relation to final hearings. So it might be said that any claim that is generated is going to be very difficult to enforce. But there are rumours that the employment tribunal system will be embracing remote hearings with all its might in the not too distant future, in which case the situation may change. So those are my brief comments on the scheme, and I'm happy to take any questions or comments from the panellists, or indeed from any of our guests.
So Richard, while I've got the line, we've had a couple of questions, so I'm going to read some of them out. I think you've partly dealt with this one but one of our attendees has written, although I appreciate that employers are permitted to make you take periods of leave during a furlough period for which they must pay the full salary wage, is an employer permitted to deduct a pro-rata period of leave based on the length of the furlough period from an employee's leave entitlement?
The basic question, the basic rule with leave is you can take it, subject to certain variations, once it's accrued. I don't think that an employer is entitled to deduct from holiday pay unless they have varied the contract so that the contractual rate of pay, which is the starting point of holiday, has been reduced pro rata.
Okay, good. I think that answers the question satisfactorily. Our correspondent also asked, and this actually brings to mind several other questions. As an employee, my employer notified me that I was being furloughed and issued the statutory letter. My retrospective understanding is that furlough can only be used by agreement of all parties. That being the case, what would an employee's rights to redress be? So just taking that in stages, it is right, isn't it, that you can't have a furlough imposed on you. There has to be an agreed variation. It's a consensual process.
Yep, absolutely, absolutely. But of course, in many cases, the employee will be only too happy to agree to a furlough in order to maintain some semblance of income. The other point about that is, of course, what will the position be if they don't, if furlough is imposed on the employee? Well, the answer to that is it will be a repudiation of the contract, and the employee will be able to claim, at the very least, their notice pay if they were terminated unilaterally and instantly rather than through notice. And of course, those employees who have very substantial notice periods in their contracts will be feeling very thankful that they do so at this time. I was recently advising an employee who had a 1-year notice period. Well, the effect of that was that one way or another, the employer had to pay that employee either as wages or as damages for the whole of the year from the point of termination. And when you consider that that particular employee may well struggle to get any other job during that period, that is, of course, a very considerable benefit. Notice pay is worth having, depending on your length of notice, in the current climate. The other thing is, if the employer has repudiated the contract, that will be almost certainly an unfair dismissal. The question is whether the employer and the tribunals will decide that, though that is the case, you would have been dismissed in any event had a proper process been followed, in which case your remedy will be limited to your notice pay. It is, of course, the case that more interesting questions will arise for that employee if some people were furloughed and some people weren't. Some people were dismissed and some people weren't, sorry. The question would be, well, why was X dismissed during the COVID crisis, but not Y? And there may be questions to be asked there about the fairness of the dismissal. But in many cases, the number of employees who are being dismissed will be so substantial that the likely outcome is an award of notice pay, valuable though that is, with little or no further compensation. Simon, are there any further questions, or is that?
I have just a straightforward question in relation to furlough. When you're calculating a period of continuous employment,
yep,
to qualify for the tribunal to have jurisdiction, a period of temporary layoff would still count towards your 2 years.
Yes.
So the question is whether or not a furlough is a temporary layoff in those terms.
Well, the question goes a bit deeper than that, actually, because the starting point is that the contract of employment remains in effect. The employee is not being asked to do any duties, but they have a contractual right to payment, but the government, as it were, reimburses the employer. So I think there's a strong argument that you never get to lay off because the contract of employment remains in effect during the furlough period. That's my preliminary view. I'd have to look at the definition of layoff again. I haven't for a while, I confess, but I don't think an employee is regarded as can be regarded as being laid off when he is being paid for his services, but the employer is choosing not to take up those services.
Yeah, I would be staggered if that counted to break continuity of service.
Yeah, I think that's right. And that, of course, may be the reason why some employers are choosing to make redundant, because being savvy, they have become aware that if a particular employee is allowed to remain in employment for another 3 months under the furlough scheme, that will take them over the 2-year qualification period.
Yeah. So following your argument through then, talking about a legitimate reason for a redundancy, so if they chose to make the person redundant in order to deprive them of that, of passing that hurdle, rather than for a legitimate business reason, then you might be able to challenge the basis on which the redundancy decision was taken?
Well, no, I don't think so, because the starting point is that to bring an unfair dismissal claim, you have to have 2 years service at the time you're dismissed. Whereas on the hypothesis we're looking at, it's the employer ending the contract before 2 years are up and because of the need to end it before 2 years are up. So I don't think that would itself generate a claim.
Interesting. Okay, thank you for that.
Thank you.
Richard Hunt's has a question as well, which was, what if you just demoted someone without discussion or consent? Would that be permissible in the current climate?
I mean, the starting point is that I assume that the position is a contractual position. Clause 3 of the contract says you are employed as whatever. And then during this crisis, and because of the crisis, the employer demotes the employee. That would be probably a repudiation of the contract, entitling the employee to resign and claim constructive dismissal. But they are unlikely to do that in this climate because staying in employment is precious. It could be that the employer is even more savvy than that and gives notice to terminate the original contract and to re-engage on a different contract with a different role, again because of the COVID crisis. In that situation, the employee would be entitled to bring an unfair dismissal claim because of the termination of his original contract, and he can do it even if he continues to work under the new contract. That is the scenario in which the employer might well argue that even if there was no redundancy, there was some other substantial reason for the dismissal, namely the business was in meltdown or some other such thing. And I think that argument might have a reasonable chance of success, given the band of reasonable responses test and that sort of thing. Even with a constructive dismissal case, an employer is entitled to say that constructive dismissal was for a legitimate reason, and that he or she or it is acting within the band of reasonable responses. And I think that in that situation, a tribunal would probably find that the dismissal, though constructive, was unfair.
I mean, it's worth repeating, I think, always that until you've got those magic 2 years, how few rights you have as an employee under our law.
Yeah.
And that you can be dismissed with notice without good reason. And once you've got 2 years, of course, the employer has an obligation to only dismiss you for a fair reason. And the flip side is, before 2 years, it can be for an unfair reason, as long as, of course, that doesn't mean a discriminatory reason or one of the protected reasons, which is essentially health and safety and whistleblowing.
Yeah.
But I think a lot of people think that they have a lot more rights until they get to 2 years, which comes back to a point you made, and I think Hans commented on in a question earlier, which is how people can use the 2 year magic point as a reason to get rid of people to avoid them having those rights and obligations. It's always been a gap in our law. And of course, it was much easier when it was 1 year, but that was changed good 10 years ago. So it's still pretty hard.
I mean, I think there may well be some constructive dismissals or otherwise under Section 100 of the Employment Rights Act. I mean, we have a family friend who resigned from her job in a particular high street business, which was a very much consumer-orientated business, on the grounds that the employer had not made any significant efforts to provide protective clothing or social distancing or whatever in the store in which she worked. And it seems to me that there is at least a strong argument that that is a constructive unfair dismissal under Section 100 of the Employment Rights Act, or some analogy of that anyway.
That's interesting. I've not thought about that. Yeah, that's a good one.
I mean, like today we have, Simon, sorry. Today we have myself received few phone calls from employment inquiries, and I've noticed a trend where people have signed a contract to start work with their employer, and there has been a meeting, and then the employer has withdrawn the offer. So today I took 3 calls, and I just wanted to know, I mean, like where someone has give notice from the previous employer, left the job, and was planning to start a new job, sign the contract of employment, and then later on today receive a letter to say that they have the company has withdrawn the offer. Any comment on that, please?
I think that those individuals are in a uniquely difficult position, because even if there is a contract of employment, and there would be an argument about whether the contract was agreed or was still under discussion, but even if that person is held to have been employed and then almost immediately discharged by the prospective employer, then there's the problem of the 2 year rule. And how it is, if it can be said, that is still a justiciable unfair dismissal, and you'd have to be looking at the Equality Act and so on and so forth. You might go back to that employer and say, look, I think I would like you please to furlough me instead of dismissing me. I appreciate your circumstances, but I need the JRS scheme to be operated in respect of me. And the employer, if they are reasonable and well informed, may go for that. Why shouldn't they? but that cycles us back to the question of what your remedy would be if they refused. Yeah.
Yeah, I mean, I think I was advising on a case like this, a couple of them recently, and it seems to me that employment law doesn't really offer much of an answer to it. I suspect if you've been offered a job offer and you've accepted it, and then you act to that and you suffer losses to your detriment, you might be able to bring a claim in the county court for breach of contract. But I don't think employment law is really much of an answer. I suspect for high value claims, you'll have to bring it in the county court. But the law never did provide protection for that, even pre-COVID-19. I always thought that it was a big, well, I don't know whether weakness is the right word, it was a gap, whether that was intentional or otherwise. It wasn't uncommon for people to resign, leave jobs, and then their job offer fall through and they were left high and dry. I mean, it's not an uncommon problem.
I mean, I think if I knew someone in that situation, I would be inclined to advise them, as well as going to their prospective new employer, to go back to their old employer, and depending on the dates when they were working for that employer, to see whether that employer would take them back to furlough them. I mean, it's, you know, they might not. Depends on how good the relationship was.
It depends how spectacular your resignation was.
Yes, it does, doesn't it? It does, very much so.
If you really went for it, you know, in a really dramatic fashion, followed by a Twitter firestorm, then it might not be so possible.
Yeah, yeah. Absolutely.
Hans has asked in a question, what is considered a fair reason to give someone notice under section 98(1)(b)?
So, well, there are a series of, obviously, of reasons which are potentially fair reasons for dismissal, and they are misconduct, capability. Then there's some other substantial reason that it's become illegal for the claimant to work. Someone, have I missed any others out?
Redundancy. Redundancy,
yeah, yeah. But those are really just the starting point. In most employment tribunal claims, the reason for dismissal is pretty much agreed, because it's usually in a letter of dismissal. The question is, was the employer acting reasonably within section 98(4)? And that is where the battleground is. And that is why employees with more than 2 years service have a decent argument if they are made redundant rather than being furloughed. And the argument is, I know redundancy is a potentially fair reason for dismissal, but it was simply not reasonable to dismiss me when you had the opportunity of putting me on the furlough scheme at no cost to yourself.
Mm. Well, that's an odd thing, isn't it, fairness in employment law? It's troubled employment lawyers for a generation, if not more, because I suppose if you take a classic example where someone is dismissed because of ill health, of course, the employee often thinks that that's extraordinarily unfair because it's not their fault, they've done nothing wrong.
Yeah. I
suppose it's important for everyone to remember that the fairness comes from the employer's point of view and less the employee's point of view. And
well, that's right, but it's clear in the current situation that those who are sick and unable to work, or who have to remain away from work because they are part of a family that is isolating and so on and so forth, those people can be furloughed. So whilst normally in the face of sickness, employers have a very broad latitude to dismiss, unless disability kicks in, disability discrimination, put that on one side. In the current climate, they have an alternative. They can furlough. And it is clear that the government intended people who are sick with the COVID virus or in any of those related conditions to be covered.
Yeah, it's an interesting point. It's,
we have a question from Harun Khan in where I believe Arun is he's speaking about the same employees in the same company. What recourse do those employees have where employers are topping up some employees' wages, but others are being paid only in line with the furlough scheme?
That's a very, 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 very good and very, very interesting point. And it's such an interesting point. I hadn't thought of it before, so I'm going. But I have this to say. That employer is taking needs to have had some good advice before taking that differential approach to topping up, and that for this reason. Suppose that one of the people who was topped up was doing the same job as another person who wasn't topped up, and there is a difference of gender.
Yeah,
that would generate, in my view, an arguable equal pay claim. Another point, of course, is that there may be further applications of the Equality Act to that claim. Unless the employer has topped up or not topped up all the people doing the same role in each case, you will have a potential claim for less favourable treatment if there's a difference in gender, race, age, and so on. So
you also might have a constructive dismissal claim if you took it that seriously, because if your colleague was topped up and was being paid £8,000 a month, and you're just getting the £2,500, even if you didn't have a protected characteristic, but it was that person was the MD's mate, then I suspect you might have an argument on breakdown of trust and confidence and related issues.
I think you would, though I think it's doubtful whether you'd choose to, as it were, fire that particular gun since it involves resignation. But of course, you could put in a grievance. That's for sure.
I mean, I've advised companies actually often that they should top up if the effect of the because for some workers, actually, the statutory scheme doesn't give them the London living wage.
No.
So some companies are choosing to pay to top everybody up to make sure that everybody is being paid a minimum of the equivalent of the London minimum wage. And that means some people are getting topped up and some aren't. And I think that's absolutely acceptable.
Yeah, I think that's right. And the other thing, of course, is that, again, it's very important to bear in mind at all times the contractual basis of the scheme. If the employer has not properly varied the scheme, the contract of the employees who are not being topped up, unbeknown to him or her or it, they will be accruing an unpaid debt consisting of the proportion of their salary that was not topped up. Putting it another way, the employer must make sure that they get a proper contractual agreement to the lower furlough salary.
Right, well, moving on to another question from the mysteriously named user. He asks, how practical is it for an employer to unfurlough employees and furlough other employees within the same company in order to share the financial stress amongst the workforce? Are there any obvious pitfalls to be aware of in respect of this?
I think that is a very good question. And the answer is that, again, you would need the agreement of all concerned. So what you would need is, effectively, what's being envisaged here is a sort of furlough by rotation, month on, month off, which actually, of course, has some health benefits as well, because it enables you to rotate your workforce through the office. But you could rotate them on furlough. The need would be for a proper contractual variation of the two groups, which might not be the most practical thing in the world to effect and record, but I think it could be done with a bit of thought. I think it's a very good idea, actually.
Yes, I mean, I've seen some companies doing group, or in fact Zoom consultations with all the workforce and trying to get as much buy-in initially as they can from everybody on agreeing furloughs. And that's actually worked because everybody understands either they furlough or there'll be redundancies. And then people have allowed them to be furloughed, and then the companies have done a rotation scheme, which I think makes a great deal of sense. I also suspect we're going to see a lot of rota and furloughing going forward as we go in and out of lockdown, with people being furloughed on, furloughed off, depending on how long the scheme goes, but also people being allowed into the office on a rota. So I think this level of organisation is going to have become very, very significant. Haroon's also asked if employers are required to do a phased return to work for furloughed employees, how can this be done fairly? With consultation, I suppose, is the simple answer.
I think also that I don't think, as I understand it, though I may miss something, I don't think employers are required to give a phased return from furlough. Though, of course, there could be advantages in doing so. The furlough is for the period defined in the contract.
Yes, I mean, thinking it through, I'm not even sure it's allowed, is it?
No, it's not, is it? Because they will be doing some work.
They'll be doing some work for the company, so I think it's absolutely banned. I can see if you took them off contract, or took them off furlough and put them back onto normal working, then you can enjoy some sort of phased return to work as you would do with an ill health case. But yes, with a furlough, you can't have, you're either completely furloughed or you're completely unfurloughed. I don't think there's any grey in that.
Yeah. It strikes me that this is this is a very good example where employee buy-in is really important. Actually, I mean, if you're an employer, well, one of the points to note, of course, is that if you make large numbers of employees, if you're proposing to make large numbers of employees redundant, large numbers of employees redundant, then you're into the collective consultation provisions of the trade unions and labour relations consultation legislation.
Richard, your mum, she's really persistent.
I think it probably is her, actually, unfortunately. So I want to have this off. If you're proposing to make appropriately large number of employees redundant, you in principle have to collectively consult before deciding, if you do, to put on furlough instead, which I think is something that has caused larger employers quite considerable difficulty. How do you consult with people when they're all at home?
We've had a follow-up question from the mysterious user who's unmasked himself as Chris, and he suggests that a phased return could involve some employees returning to work while others remain in small groups to pressure test social distancing, perhaps. I suppose if that means if you've put 20 people on furlough, can you bring 5 off furlough and leave 15 on furlough fairly? Which is an interesting question, the unfurloughing, I suppose, is something that we've not really ever thought about yet. But that's an interesting question. If you're advising a company, Richard, what would you advise them about unfurloughing?
Well, of course, that's where some of my difficult examples might kick in. When one of the staff says, well, I'm sorry, I've got to care for my children off school or my elderly relatives and stuff. I don't want to be unfurloughed. And then I think that'd be a really difficult issue, raising Equality Act considerations. But I'm very taken with this idea of how an employer, how if at all an employer can deal flexibly with significant numbers of employees. I think in my own mind, I've often thought of it as a one-to-one situation, the employer and a particular employee. And this might be a situation in which an employer would be very grateful for having some kind of works council, which are mandatory in some bigger companies and not in smaller ones. Of course, the employee, it is possible to set up a situation under which the works council can consent to variations which bind all employees. I mean, I think there are problems with that, but it's certainly one possible way of introducing mass flexibility into your furlough arrangements.
Yeah, it poses quite a lot of questions which we're just not used to dealing with, because I suppose furloughing has never existed, has it, in English law? This concept is brand new. Yeah, and so there's obviously no law in it. I mean, the guidance, such as it is from the Home Office, is from the government, is not that useful. I mean, for obvious reasons, because it was written in 5 minutes flat. So it is an interesting thing.
I mean, it is also very striking how this new creature, furloughing, interacts with established principles of law, isn't it? Like the need to vary a contract. It's easy to state, but difficult to implement when you're dealing with more than 2, 3, 4, 5 employees.
Yes, and the sheer mechanics of getting the variation, getting some form of, presumably you've got to pay at least £1 for the agreement to the variation, and you've got to get it signed and done properly. For big companies, it must be logistically a nightmare, and I suspect very many of them simply felt they can impose it.
Yeah,
and haven't actually done any discussions about it. Of course, I suspect the law will be quite tough for employees. Just to repeat that, because I suspect if they then take that without complaint and go on furlough for several months on end, they're going to have thought to have agreed it by conduct, and so can't really complain about it later, which is probably a point worth stressing, that if people have been made furloughed against their will, they need to make sure they've either not particularly accepted it or not agreed it and just gone quietly, because then their conduct will have bound them.
Yeah.
Just on, it's a separate point entirely, but it's more about the redundancies, and more so with larger companies, the process in which you go through to make a person or a number of people redundant itself is quite lengthy in terms of giving notice to all, sitting with individual meetings, looking for alternative arrangements or jobs in the company, and then the redundancy. There has been a lot in this scenario, in this situation, where that process has very quickly gone through without due consideration, and that in itself can lead to an unfair dismissal. So just wondering if there's any comments on that.
I would expect there to have been large numbers of employers who have made employees redundant in circumstances such that under normal conditions that dismissal will be unfair because the proper process wasn't followed. I recently came across an employee who was just fairly senior, called into an office and told he was being made redundant because of the crisis. And that was it. No appeal, even though he'd been there many years.
We've had quite a few clients who've come to us and said they've been made redundant. Speak to them about the process. They've had none whatsoever, literally a day's notice, and that was it.
But of course, the question is what, in practical terms, follows from that. I mean, there is a slam dunk unfair dismissal on the procedural grounds. The question is what compensation you're going to get, and the assuming, and I assume that a redundancy payment is paid insofar as one is due. And the answer is that the first question is, have they had 2 years service? Because if not, they're stuffed. And if they have had 2 years service, was there any realistic chance that a proper process would have led them to retain their job? I mean, it's the so what question.
Yeah.
And if there was, then the employer is liable to make a compensation payment, which is effectively the employee's losses likely to be large brackets in the current climate, multiplied by the percentage chance they could have kept their job if a proper process had been followed. And I mean, there are two, if you're advising in that situation, there are two conflicting considerations. One is, practically, you know, any court or tribunal is going to have a lot of sympathy for an employer in this situation. But on the other hand, if you, excuse me, made some employees redundant and some not, and furloughed some others, there are going to be real questions to be answered about why people were in the different groups.
That's right.
You know, and if it turns out that all the people who were made redundant were the women with children,
exactly,
or, you know, different race or whatever, that, you know, I think and of course, because of the pragmatic situation, the employer will probably have very little documentation to explain why they did what they did. And so if this comes to be looked at several months down the line, there will be some difficulties.
Can I ask a question about how many months down the line? I have a memory that in relation to claims relating to redundancy terms, that the limitation periods, which are ordinarily 3 months to bring a claim, in respect of redundancy terms, I have a memory that there are longer limitation periods of 6 months.
Again, I haven't checked this recently, but as I recollect, if you're making a claim for a straight redundancy payment, I think it's 6 months.
Yeah.
But if you're claiming unfair dismissal, it's 3. So the limitation period is potentially a problem. But in addition to that, I think it's worth saying that if you are made redundant on notice, you can bring a claim straight away, which is very useful if you're continuing to receive your notice pay. But in essence, there is a 3 month. But for all the most important claims in relation to redundancy have a 3 month period.
Great. Okay, just checking through the questions. We've had a couple of people have commented that they would like to have a private discussion. Kirsten and Faith have made comment about that. I've put an email address into the chat, which is info@otssolicitors.co.uk. So if anyone wants to have a follow-up and a discussion in a more private way, then please, you'll see that in the chat. Contact Hans, who is manning that email address, and he'll be delighted to set up any further follow-up meetings.
I mean, I will speak to you, Faye, today after this webinar, and then I think if Kirsten could please email us, and then we'll be in touch with that person as well.
Great. All right. Well, we are doing these events every week, I think, at the moment, Hans, aren't we? Is that the plan, or is it every fortnight? I can't remember now.
Yes, I mean, like we plan to do this maybe every week when there's a hot topic, hot subject. But I think like today, it was good, very informative, and thank you for making for the time that you yourself and Richard gave to us and to all the attendees. So much appreciated.
You're welcome. I'm just sending a private message, and I can't do 2 things at once. Okay. There we go. Right. You're welcome. It's been a pleasure speaking to all of you. I hope that none of you have been too adversely affected by this, although I know all of us are. But I think that's the end of our discussion today. There will be a recording of this webinar, assuming the recording technology did its job. And that being the case, then Hans, I will give you access to that recording so that you can circulate it to anyone whose details you have, and they can rewatch as they see fit.
Simon, is there anything within the technology that allows participants to just give us any feedback on how we could do things better next time?
Not really. All I would say is, by all means, there's the email address for Hans, which is info@otssolicitors.co.uk. Please send in any questions, feedback, concerns, that you have, and by all means we will do our best to address them. Come next week if you want. That will be advertised, I think, through the Eventbrite page as well. And I hope you will stay safe, enjoy the torrential rain that's certainly going on where I'm living at the moment. And yes, thanks all. I shall end this now. So good afternoon to you all.
Good night. Goodbye to all of you.
Thank you.
Thank you.
Thank you.